Are verbal agreements enforceable? The answer might surprise you. There is a misconception out there that verbal agreements are not enforceable. However, in California, verbal agreements are enforceable and binding, but not all contracts should be verbal in California. There are some exceptions of contracts that must be in writing. For instance, if your contract term is greater than 1 year from the completion of that contract, that agreement must be in writing. If you have an agreement for the sale of property, that agreement must be in writing. If your agreement is for a lease longer than 1 year, that agreement must be in writing. But for those other agreements that don't apply, and there's other agreements that need to be in writing, and you should look those up, but for the agreements that are agreeable verbally, there are some things to make them more enforceable if you have to go to court. For instance, to enforce a contract, it's better that you have other people who witness the agreement between the parties. In addition, if you have either text negotiation or email negotiations based on that verbal agreement, that will help you enforcing that agreement in court. So just because the agreement is verbal, not in writing, doesn't necessarily mean that that can't be enforced. So be careful what you say out there and what you agree to.